the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files with Leslie Tucker, the principal at Williams, Edelstein, and Tucker. I'm your host, Jonathan Sarr. So this is a new series that we're publishing and producing right now. We're super excited to bring it to our Fair Housing Insiders audience. Leslie, turn it to you. Why are we doing this? Are you excited about this new segment of our show?
I am. Thanks, Jonathan. I'm really excited about this new segment. This is going to give me an opportunity to let you guys know what kind of cases are being filed out there, what issues are at play, and not only talk about them, but then talk about kind of what the underlying fair housing issues are. And hopefully that reaches out to you in your jobs and in your positions, and hopefully you can take away something helpful.
Absolutely. Yeah, I am super stoked about this. I think this is going to be a wonderful opportunity for our audience to kind of see what can happen and why it's so important to understand fair housing and employing best practices on a day-to-day basis. So yeah, super excited to have this segment. So let's focus on our topic for today. So hello, everyone. This is episode 1. We are talking about disparate impact. The case that we're talking about today was filed based on the allegation that the property would only lease to people that could speak or write in English. Leslie, can you elaborate?
Yeah, so this case alleges that the housing provider, which owns and manages some properties in New York State, had a practice of refusing to rent to applicants if that entire household is LEP, which stands for Limited English Proficient. And this allegedly was the case even if the applicants offered to bring in their own interpreters or assist the managers with translating documents for themselves. So once this situation came to light, a complaint was filed. And this lawsuit specifically was filed by a local private fair housing organization. And that organization kind of relied on this guidance that HUD issued back in 2016 that talks about protecting people that are LEP. Well, the housing provider came back and said, look, language itself is not a protected category, so you really don't have a claim here. They also said that HUD guidance is not a legal authority that you can use, in this lawsuit. So that was kind of their argument in their own defense. The court ended up not agreeing with their arguments and denied the housing provider's motion to dismiss. After that, the parties ended up settling the case, so it is now resolved.
Okay, thank you for that explanation. So just a couple questions regarding this case. Our first one, does this mean that language is a protected category under the Fair Housing Act?
So no, not technically. Language is not explicitly a protected category under the Fair Housing Act. However, what we know from HUD guidance and from these cases is that HUD views language as a representation of someone's national origin, so that if someone's being discriminated against based on the language that they speak, it's essentially the same thing as being discriminated against because of your national origin.
Got it. Okay, thank you. So what if the employee has no idea what the applicant's national origin is? Can it still be considered national origin discrimination?
Which is a really good question. Typically in discrimination cases, the housing provider has to actually be aware of the protected category that's involved in order to, act based on that protected category. This is not the same thing, though. This is disparate impact. And disparate impact isn't about intentional discrimination. It's about, often unintentional, negative effects that certain policies and practices have. If someone is making decisions based on someone's language, that does end up having the effect of affecting, people's eligibility based on their national origin. So even if you don't know what country someone comes from, if they don't speak English, that is still a disparate impact on people's national origin.
Got it. Okay, thank you. So third question. If an employee cannot communicate with an applicant due to a language barrier, how can the management employee avoid violating the law?
So there are multiple ways. If an employee doesn't speak the same language as an applicant or a tenant, there are multiple ways that you can kind of be in compliance. And that's just basically doing your best to communicate with that tenant or the applicant. If they want to bring in an interpreter, that's great. They certainly aren't required to do that. But you can also use translation apps. You can use translation services that you can, call up on the phone. So there are multiple ways that you can attempt to communicate with applicants as long as you are doing that effectively.
Okay, very good. So is the law different if the property has no federal funding?
So properties with federal funding that are HUD financed or RD properties certainly have this explicit requirement that you have to be able to communicate effectively with your applicants and tenants. If you are a conventional property with no federal funding, you still do have that responsibility, because the failure to try to communicate with people is viewed as national origin discrimination, as we learned, and as this case taught us. So even conventional property owners and managers still have that obligation to take measures to communicate.
Awesome. Thank you so much for explaining this to us. An interesting case to take a look at. We appreciate everyone who's tuned into this new facet of our show, this new segment. Thank you for tuning in. We'll see you next time. Take care, everyone.
Bye.